Hi everyone, great to see so many people join us online today. Welcome to this webinar on AI and life sciences patents, do's and don'ts, which will be presented by Jeremy Smith and Alex Robinson, UK and European patent attorneys at Mathys Squire. They will be introducing themselves just a little later on. My name is Sabah Ismail, BD exec at the firm, and I'm delighted to be your host for today. Just before I introduce our speakers, I would like to highlight an upcoming webinar that you just saw from the previous slide, which is patent drafting for success in Europe, that will take place on the 25th of March. Links to register will be circulated post this session. It is without my further ado to hand over to the presenters, Jeremy and Alex.
Hello. I'm Jeremy Smith. I'm a partner in the IT and engineering group at Mathys Squire. My own background is actually semiconductor electronics, and I've spent a number of years as a designer in the electronics industry before moving into the patent profession, where I have specialized in electronics, computer implemented inventions, and in particular standards related telecommunications technologies. I have had an interest in artificial intelligence for as long as I can remember, and so being able to be involved at the earliest stages with cutting-edge AI-implemented innovations in my role as a patent attorney is somewhat of a dream job. Where it comes to life sciences, I'm far less knowledgeable, and so that is where my colleague Alex comes in. So over to you, Alex.
Thanks, Jeremy. So I'm Alex Robinson. I'm a managing associate in our life sciences and chemistry team. My own educational background is in chemistry and then a PhD in what might generally be described as biophysics, with a small amount of molecular biology involved, and I've sort of built on that since then. So I'm not a computer programmer, I'm not an electrical engineer or anything like that by training, but in my practice in the life sciences, I've begun to see artificial intelligence aspects becoming more and more prevalent over the last few years. And so hopefully between Jeremy and myself, we'll meet somewhere in the middle and give you a good clue as to what to bear in mind when prosecuting artificial intelligence patents in the life sciences in Europe. Back to you, Jeremy.
So before getting into detail on how we seek to protect AI in Europe and the related nuances of European patent law, it's worth taking a step back to actually have a think about what AI actually is. Now, at the philosophical level, a discussion of what does and does not constitute true or general AI is the stuff of multiple PhD theses. But for our purposes, it probably suffices to think of AI simply as apparent intelligence exhibited by a machine. Of course, this itself leads to the somewhat intangible questions of what constitutes real intelligence and whether a machine can ever truly exhibit intelligence. But if we spend time worrying about these questions, we'll never get anywhere meaningful. To some extent, whenever someone creates a machine to do a task previously thought of as requiring intelligence, that task is swiftly removed from the definition of intelligence. So at the philosophical level, I will simply leave you with the words of Douglas Hofstadter, the renowned scholar of cognitive science, that AI is whatever hasn't been done yet. As patent attorneys, we should, of course, be more concerned with what AI is at a practical or technical level. Generally speaking, AI is little more than mathematics. In the case of an artificial neural network, for example, the AI can typically be boiled down to a complex mathematical function of a set of weighted environmental inputs that provides one or more outputs representing some kind of desired action in the case of an autonomous vehicle, or answer to a specific question. The mathematics of artificial neural networks are, of course, not the only types of mathematics used to mimic intelligence. There are many others, such as probabilistic modeling, evolutionary optimization, and the list goes on. One challenge facing us as we seek to protect AI inventions is that the AI is effectively a black box. Generally, you do not know exactly what is in it unless your invention happens to be an improved AI architecture itself. And even if you do know the underlying mathematical function, the values of the variables that make the AI function do what it does are numerous, are intangible, and are subject to change over time as the AI is trained. Of course, whilst AI can be reduced to little more than mathematics implemented on a computer, it is extremely powerful and is becoming all-pervasive with applications in all fields of technology, not least biotechnology, which is, of course, why we're here today. So over to Alex just for a few statistics.
Thanks, Jeremy. So many of us who are practicing in areas such as pharmaceuticals, like myself, are increasingly coming into contact with inventions that involve AI in some way. And it seems at the moment that nearly every month there's a headline telling us about some new and exciting advance made by AI, whether it's drug discovery, for example, using AI to assist in the design of new drugs or screen old drugs against new targets, as shown in these two headlines here, or in medical diagnosis, for example, in analyzing X-ray images. And more spectacularly, in my view, though perhaps I'm biased here due to my background, the recent headlines about the DeepMind AI, which, as you know, made huge progress in accurately predicting protein folding, which is something that just a few years ago seemed decades away from being solved. Now, this recent increase in the use of AI to solve chemical or biological or medical problems is reflected if you look at the EPO patent filing statistics. Now, there's not time to go over these in detail today, but what we do see is a very rapid acceleration, really since about 2015 or 2016, in patent filings relating to the use of machine learning, which is what we now tend to think of when we think of AI, in bioinformatics, structural biology, drug screening, and that sort of thing. Now, there are a few things to keep in mind here. First of all, the EPO's experience with AI as applied to the life sciences in particular is still at a very early stage. In quite a few of the fields I mentioned above, things like genomics and so on, over half of all the patent applications relating to AI in those fields have only been published in the last 2 years. Some of them won't even have been examined yet, or they will still be undergoing examination, never mind oppositions and appeals. So that means that both we as attorneys and the EPO are still figuring out the details to some extent of what the patentability requirements are and what the boundaries are. And there's very little case law from the boards relating to, for example, AI inventions in bioinformatics as distinct from computer implemented inventions more generally. Another point is that due to how these inventions are classified under the EPO's internal system, in many cases, the examiners or the appeal board members who end up looking at them are going to be from an electronics or computing background. So that's going to influence the way that they think about these cases. Their approach to examination is potentially going to be very different from what you might be used to if most of your experience before now, like mine, has been in traditional chemistry or biotech inventions. So over to Jeremy to talk us through some of the examination philosophy that underlies this.
So yeah, many of the issues surrounding the protection of AI in Europe actually originates in a number of so-called subject matter exclusions, which some of you may be familiar with. They're set out in Article 52 of the European Patent Convention. These subject matter exclusions were originally written to exclude what were deemed to be non-technical or abstract inventions at the time the European Patent Convention was drafted. And as many of you that are familiar with the US patent system will note, the subject matter exclusions have some parallels to the way the courts in the US have defined patent eligibility to exclude laws of nature, physical phenomena, and abstract ideas. On the one hand, the law does confirm that patents shall be granted for any novel and non-obvious inventions in any field of technology, but on the other, explicitly states that mathematical methods and computer programs shall not be regarded as inventions for the purposes of granting patents. Does this mean that we cannot protect any AI implemented invention? Well, no, because the exclusions themselves are limited by qualification that they shall exclude the patentability of subject matter only to the extent to which the European patent application or European patent relates to such subject matter or activities as such. It is this qualification that allows many, but not all, AI implemented inventions to become patent eligible. The question of what AI implemented inventions are and are not rendered patent eligible by the qualification depends on whether or not they're considered to have a sufficient technical character, as evidenced, for example, by the technical contribution that they make. Whilst AI implemented inventions are relatively new, the Boards of Appeal of the European Patent Office have grappled with the question of what type of computer implemented inventions and applications of mathematical methods have the requisite technical character to take them out of the subject matter exclusions for decades. Ultimately, the European Patent Office settled for a relatively simple test of whether claimed subject matter was or was not excluded from patentability that, on the face of it, seems to make it very easy to sidestep the exclusion altogether. This is often known as the any hardware test. Effectively, the test means that as long as the claim recites something that is not excluded subject matter, even something as simple as a general purpose computer, then the claimed subject matter is not excluded from patentability. Well, that's fantastic. But, and it's a huge but, any subject matter that does not contribute to the technical character of the claim is then ignored for the purposes of assessing inventive step. Thus, where you have a claim that recites a mixture of technical and non-technical or abstract features, but having technical character as a whole, for example, by virtue of being implemented on a computer, is assessed with respect to the requirement of inventive step by taking account of all those features which contribute to the technical character, whereas other features that don't make any contribution are considered not to support the presence of an inventive step. If the technical character of the claim stems only from the fact that it is implemented on a computer, therefore, and the novel technical feature provides no technical contribution beyond that, then the claim is considered to lack an inventive step. If, on the other hand, the novel non-technical feature, say a novel feature of an operating system, provides an improvement in how that computer operates, for example, it makes it faster, more efficient, more secure, or the like, then the non-technical feature contributes to providing an improved computer, provides a technical effect, and is therefore inventive. Effectively, you can see that the European Patent Office has neatly sidestepped what has become the thorny issue of excluded subject matter or patent eligibility by moving the entire consideration of technical character and technical contribution out of the somewhat elusive realm of the subject matter exclusions and into a more tangible realm of inventive step. And this makes some sense. Inventive step in Europe has long been tied to the concept that an invention is a technical solution to a technical problem. Novel features that do provide any technical effect or solve a technical problem are thus, by definition, potentially inventive, and the converse applies too. The core issue of what is technical remains the same, but from the European Patent Office's perspective, it becomes easier for examiners to identify issues and articulate their objections, whilst of course there are still extensive grey areas. From the attorney's perspective, this approach provides a modicum more certainty and predictability, thus allowing applications to be drafted that actually preempt possible objections to provide the best prospects for achieving a commercially valuable scope of protection. Just move to the next slide, please. So the EPO has somewhat helpfully provided some guidance in how they'll treat AI inventions in the form of a relatively new subsection of the guidelines for examination that are used by Patent Office examiners. So these are available publicly if you want to look them up. The new subsection, unsurprisingly, treats AI as a subclass of mathematical methods, defining the AI and machine learning as being based on computational models and algorithms for, amongst other things, classification. And it indicates that such computational models and algorithms are, per se, of abstract mathematical nature, irrespective of whether they can be trained based on some training data. The guidance indicates that the EPO will treat certain AI-specific terminology with extreme caution, confirming that merely reciting the use of an AI using such terminology, however technical that terminology may sound, will not be enough to convince the EPO that the feature contributes sufficiently to the technical character of the invention to be considered to provide an inventive step. The new subsection of the guidelines also explicitly confirms that if the AI, referred to the classifier in the examples, is deemed to contribute to serving some technical purpose, then related methods of training the AI and generating the training set for training the AI are also likely to be considered to contribute to the technical character of the invention and thus be more likely to be accepted to be inventive. It is also evident that if your AI is classifying technically generated signals, for example, an image of cells or something, say based on a characteristic feature of those signals, so perhaps for the appearance of some artifacts of a particular shape, intensity or size within that image, then this will likely go a long way to convincing the EPO that these features contribute sufficiently to the technical character of the invention to warrant patent protection. However, novel classification alone is not enough. If classification is considered only to contribute to a non-technical field, then it will be considered to lack an inventive step. Whilst the newer subsection of AI and machine learning provides only limited examples from the developing case law, it also makes clear that the wider principles relating to mathematical methods provided elsewhere in the guidelines also apply, thus allowing us to draw some reasonable conclusions on what considerations will be important for securing protection for AI implemented inventions in the future. So if we take a step back and we look at what the guidelines say about mathematical methods more generally, we conclude that any claim directed purely to AI is likely to face difficulties and be treated as patent ineligible. Even if we recite brand new and extremely clever architectural improvements to the AI, that may not be enough itself, because in essence, all you're deemed to be doing is modifying the underlying mathematical method without providing any technical contribution. The any hardware test nevertheless still applies, and so if you introduce any technical means into the claim, your subject matter is no longer excluded, but instead moves into the realm of inventive step. But just as a claim to using a pencil for writing a new mathematical formula or algorithm would likely be considered to lack an inventive step, so too would a claim simply to using a computer to implement a novel AI. There may be some leeway to argue that a new AI architecture provides a better, more intelligent computer per se, but there are likely to be difficulties, and it is essential that the technical purpose is clearly evident from the language of the claim itself. Merely reciting a general technical purpose is, however, not enough. The claim needs to be specific. If you want to get a broader claim granted that covers a wider range of applications for your AI, then it's important to articulate this range of applications with some specificity in the description itself. In this regard, a more specific and detailed description of the range of technical applications will make it more likely that the EPO will allow a more generic technical purpose to be specified in the claim, a claim listing a number of alternative purposes perhaps, or multiple independent claims directed to several different purposes. Now, having given you a very quick whistle-stop introduction to the way EPO treats AI inventions in general, I'll hand over to Alex, who will provide you with more practical insights related specifically to life sciences inventions.
Thanks, Jeremy. So from all of that, you can hopefully see that this question of what is meant by technical is absolutely fundamental to the EPO's approach. Unfortunately, it is also incredibly difficult to define with any precision. So to help to illustrate the EPO's approach, on this slide, I've included a number of examples of introductory claim clauses of the sort that we might typically see for AI-related or just computer-related inventions in general in the life sciences. All of these are computer implemented, you can see in the claim language there, so there's no question of them being excluded subject matter as such. That is, there's no question that they are deemed just to be non-patentable subject matter in principle. The question then is, well, is the purpose that I've shown in bold text in each case, is that a technical purpose? That is, if all the other claim features that I've not shown here, if all those other claim features in isolation are non-technical, does this purpose of the claim that is shown here solve a technical problem to which other claim features could contribute, so that those other non-technical claim features can then be taken into account in assessing inventive step to the extent that they support this technical purpose? Well, all of these examples, I think it's important to point out, are semi-fictional. They're loosely based on claims that the EPO has examined or that have been the subject of a couple of rare case law decisions on biotech AI inventions in particular, the numbers of which I've shown down at the bottom there if you wanted to go away and look them up, or I'd be happy to email you a copy afterwards. But I should point out that these examples are mostly drawn from presentations that have been given by the EPO itself. So the answers here are not necessarily ones that I would agree with. I think in some cases there may be room for debate, and the outcome may, of course, depend on what else is contained within the claim or in the description. But nevertheless, at a sort of first approximation, the way that the EPO might view these types of claims is as follows, indicated by a green tick for technical and a big red cross for non-technical. So let's have a look. This first one, we see that would be considered to be technical, whereas the second, relating to a statistical genetics analysis system, would be non-technical. Identifying a ligand that binds rhodopsin would be technical, but identifying a more generically defined drug discovery target would be non-technical. Identifying a phylogenetic tree, non-technical, whereas using that tree to identify a vaccine candidate perhaps might be technical. So what is the theme here? You're probably asking. At first glance, this division seems potentially to be quite arbitrary. I find it quite helpful to think of this as being, really, it's about the degree of abstraction. What is the purpose that's being served by the invention? Is it something concrete or tangible, something that you could, for example, independently and objectively determine outside of the computer? So the first example relates to a specific type of genetic abnormality that could be verified in the laboratory, for example, by counting the number of chromosomes that you can find in a fetal cell. The ligand that binds to rhodopsin, you could verify using a fairly straightforward binding assay in the laboratory. The vaccine candidate in the final example there, that obviously could be tested. But a more generally defined statistical genetics analysis, as we see in point 2 there, or a very broadly defined hunt for targets having an unknown structure or even an unknown protein, and for an unspecified drug, as we see in that fourth point, or a phylogenetic tree that shows evolutionary relationships between protein or DNA sequences. Those don't directly provide something that can be implemented in the laboratory or in the real world, and they undoubtedly provide useful information. But nevertheless, that information would require some sort of further interpretation and maybe some more subjective judgments to be made before it could translate into something less abstract. Now, of course, as I've said, in some cases, this conclusion could be arguable. It could depend on the facts of any given case. Other claim features might help turn one of these non-technical examples into a technical one. So the boundary is not a bright line, but hopefully this gives you some sort of guidance as to maybe some of the outlying examples or the types of factors that the EPA might take into consideration. So if we assume that your purpose that is either recited explicitly in the claim, as we saw on that previous slide, or might be implicit from other features, assuming that that purpose is technical, how much detail do you actually need to provide in the claim? As we've heard from Jeremy in his summary of the guidelines, the case law and the practice of the EPO say that non-technical features of the claim, such as mathematical steps, can be taken into account in assessing inventive step, insofar as they contribute to the technical character of the invention and so serve the overall purpose of solving a technical problem. But what does it mean for a feature to contribute to the technical character? Again, the question here is, at least in part, one of abstraction. The case law has established a test, which I've paraphrased at the top here, as requiring the claim to provide a sufficient link, that is a causal connection between the claim features and its technical purpose. Now, at least in the field of bioinformatics, this comes from a relatively early case, T784 of 06, and it is easiest to illustrate this principle by looking at this case and its spiritual successor. The claim at issue is shown on this slide here. So this is the claim that was at issue in case T784 of 06. Important to highlight here that this was actually a very early bioinformatics patent application, really in the historical perspective. The filing date was in 1994. And the decision that we're looking at here was issued in 2010, after this had been through a very protracted examination and then opposition procedure. So as you can see, this relates to a method of determining a genotype based on some sort of statistical analysis performed based on data obtained from genetic material. Now, although it wasn't explicitly addressed by the board, the purpose that's recited in that first clause there and that's highlighted in green, the purpose of determining a genotype, seems implicitly to have been considered a technical purpose. And step A, which requires a reaction to be performed in order to get certain information that's termed here to be a reaction value, that's clearly a tangible technical step. But what about steps B through E, which I've highlighted in red here? All of these essentially involve using the results of step A, some sort of result obtained from a reaction, to compile a data set, which is left undefined in that claim language. That can then be subjected to some sort of statistical analysis, which is also largely undefined, but which is the subject of steps C and D, in order to arrive at a genotype determination. These are essentially mathematical or abstract mental steps of taking some data that has been obtained from the real world and carrying out some mathematical manipulations of that in order to try and arrive at a conclusion. So although the overall purpose here appears to be technical, and there is at least one technical step, are these steps that I've highlighted in red, B to E, sufficiently well specified to be deemed from the EPO's point of view to interact with the technical features of the claim to serve that technical purpose? Well, the board essentially said no. On this slide, I've put some of the key lines from their reasoning. I'm not going to read those out, but the overarching theme here is basically that those steps that I showed you on the previous slide, and those of steps B and C in particular, that is the steps of forming a data set and establishing a distribution set of probability distributions, were defined at too high a level of abstraction. They were too generally framed so that the claim was not restricted to any particular mathematical process that was necessarily and inextricably linked to the claimed purpose. So a point of interest here is that in making this assessment, the board also looked at what was contained in the description. Here they said that the description provided no more than a mere repetition of the claims. There was a flow diagram of the data treatment, as will be familiar to many of us from maybe a more US familiar drafting style for process claims. but this apparently provided no further concrete details as to how the data was manipulated. In other words, it was established at the same level of generality and functionality as the claim language itself. There was apparently a reference to a particular computer program, which was called getGenos, but apparently this didn't sufficiently explain how that program interacted with the data. So even though it was a commercially available computer package, it wasn't clear from the content of the description how that software package was to be applied in service of the analysis that was specified in the claim or in the description. There were also some mathematical formulae and apparently some lines of code in the C programming language, but it was not adequately spelled out how those actually related to any of the specific steps in the claim. Now, to those of us from a life sciences background, this type of assessment maybe has something of the character of a sufficiency or enablement type analysis rather than an inventive step analysis. And one thing that occurs to me from this case is that it perhaps indicates that even this broadly defined claim language might perhaps have been salvageable if the description had been more detailed, but unfortunately we can't know that for certain. Anyway, in the event, if we go back to the claim language as we saw there, the board found that in view of the deficiencies in how steps B to E were defined, and steps B and C in particular, the link, this sufficient link between the non-technical steps in the claim and the technical purpose, that link was broken. That is, there was no inherent causal connection to the technical purpose of the claim or the features in step A. Those features therefore could not be taken into account in assessing inventive step. Only those features which I have highlighted in this box could be used for assessing the invention in the light of the prior art. And in that light, the claim was not found to be inventive. So there's an example of a claim which fell essentially for being too generically, too abstractly defined. But here's an example of a later case from the same board. This is from decision T2050 of 07. This was the same Board of Appeal of the EPO, sitting in a slightly different composition, slightly different members. The decision date was in 2013, so about 2.5 years after the decision we saw on the previous slide, and this related to a patent application that had been filed in 2002. So again, still quite early when we think about modern applications of bioinformatics and computer implemented inventions in the sort of biotech and life sciences field. This claim, in this case, had been refused by the examining division for a lack of novelty. So it hadn't been refused as relating to unpatentable subject matter as such, and it hadn't been refused for inventive step, but actually for lack of novelty. And as we can see, this also relates, in essence, to a method of genotyping, which again involves manipulating DNA, and in this case, deriving some data from that DNA, which again can be employed in a statistical analysis of some kind. Now, the Board of Appeal looked at this and in their communication ahead of the eventual hearing, raised a number of concerns, including in particular an objection relating to steps D and E, which I've highlighted in that box there. The board said that the claim appeared to relate to a method of analysing a signal, that is the signal of step C, rather than analysing DNA as such. And they said that the question therefore arose as to whether the analysis steps, D and E, relating to the analysis of that signal meant that the claim as a whole was merely a mathematical method. In other words, they seemed to hint at refusing the application as relating entirely to excluded subject matter. Now, in my view, that can't be right, at least not seen from a modern standpoint, because steps A and B very clearly relate to real-world laboratory steps involving physical manipulation of DNA. That aside, however, the board had other concerns about this claim relating to new matter, lack of clarity in respect to certain features, and lack of novelty, as with the examining division. So after a few rounds of correspondence, the applicant ended up at this amended claim. As you can see, this is quite a lot longer and more detailed than the claim that we began with, in particular with regard to step C here, which seems to have replaced the previous data analysis steps that were boxed in red on the previous slide, those that gave rise to the concern about whether the claim related purely to a mathematical method. You can see that there's now quite a lot more mathematical detail provided of how the data is to be processed, which variables are input into which equation, what they represent in terms of their relationship to the DNA, and ultimately how those are employed to determine the probability distribution which is employed in the final step so as to arrive at the desired information with regard to genotype, which is the overall purpose of the claim. Now, the board seems to have come to its senses here and noticed that, at least in this revised claim, steps A and B were unambiguously technical, so there was no question of this claim being refused as purely relating to excluded subject matter. Now, as to step C, the step that relates to the mathematical method, in this case, the board distinguished over its own older case that we considered only a few slides ago, T784/06. Concerning this step, the board said, in contrast to the vagueness of the disclosure in that earlier case, here the description made it sufficiently clear how the distinguishing features of the method, that is, those of step C, should be implemented and how they interact with the remaining steps of the claim method in order to provide a common technical result, namely a genotype estimate with an improved confidence compared to the quantitative method analysis known from the prior art. An interesting factor here, from my point of view, is that this sounds very much like an inventive step type analysis, particularly when they look at the improved confidence, which is not actually recited in the claim, I think. However, the board actually stopped here, finding this feature conferred novelty over the prior art and remitted the claim to the examining division for assessment of inventive step, which was duly confirmed. So this is perhaps a good illustration of the point that I made earlier, that the EPO is still refining its approach. We've seen a sufficiency style reasoning being performed in support of an inventive step analysis, and we've seen inventive step type reasoning being performed in support of a novelty analysis here. To borrow a machine learning analogy, the EPO still seems to be converging on an optimal solution, perhaps through its own legal version of a gradient descent analysis. But what we see is that regardless of the exact legal heading under which these claim features and these types of issues are being considered, it ultimately comes down to the same principles of how abstract is too abstract. I should note as well, as I mentioned briefly, that these cases are quite old, and even though we don't have much case law on biotech AI inventions since then, well, not yet, the general level of knowledge and expertise and the general consensus on practice at the EPO, those are generally converging and increasing over time. So in that last case, I showed you the level of detail that was in the claim that was eventually allowed, incredibly high. And you're probably asking, is that a good example of how much detail the EPO is always going to want? And I think the answer here, it is important to note, is no, or at least not necessarily. It will depend on the facts of any individual given case. In that last case that we showed, the applicant had actually tried various other versions of the claim requests, which were maybe more precisely specified than the original claim, but broader than the eventually allowed claim. But they've been hindered in that regard by the EPO's very strict rules on added matter. So it's conceivable that a broader claim could potentially have been allowed if the right disclosure had been there. At a more general level, however, I think the overarching question to be considered is whether the claim and the features specified in the claim, without gaps from the inputs of the method, assuming it's a method, for example, through to the outputs. In other words, are the features too generic or abstract? Does a skilled person need to make assumptions or deductions to determine how to implement the invention? Now, this could depend on the circumstances of any given case. Are any of the non-technical features in the claim, which nevertheless contribute to the technical purpose, are they themselves conventional? You could imagine, for example, a method which somehow involves perhaps a protein sequence alignment, and that has to be carried out. Now, if that isn't the sort of key inventive contribution that's being made, and if any conventional method of sequence alignment could be applicable, perhaps using a conventional BLAST algorithm or something like that, then maybe you don't need to say very much about that at all in the claim, other than saying you're performing a protein sequence alignment. On the other hand, if it's essential that a particular type of sequence alignment is performed, or if actually the nature of the sequence alignment is itself the key inventive contribution over the prior art, then it would be important to ensure that sufficient levels of detail are provided in the description, even if the claim is initially quite broadly specified. That would at least allow you to, in the first case that we looked at, for example, rely on the description perhaps to support a claim of that breadth, and if not, then perhaps to amend the claim so as to more precisely specify those features. But what about neural networks? After all, when we're talking about artificial intelligence these days, what most people think of in 2021 is a neural network. How much do we need to go into in describing a neural network to meet those tests of causal connections and specific links? Well, here are two examples that I've plucked more or less at random from the EPO register relating to recently granted claims in the medical imaging and diagnostic fields. These aren't anything to do with me. I have anonymized them appropriately, so they're being used merely as illustrations. What we see on the left here is that it doesn't necessarily seem to be a requirement to define the architecture of the neural network, provided that the inputs and outputs are defined and provided that it is plugged in to the wider method at a sufficient level of detail. In other words, is the purpose of the neural network clear in the context of the method? Is it clear what its inputs are, what they represent, what the operation is that the artificial neural network performs on them, even if we don't know exactly how it's performing that operation? Here we've got another example of a claim which includes some detail about how the neural network is trained. This could be, as Jeremy said, for example, where the details of the training are essential for defining the invention or form an essential distinction over the prior art. However, you should, of course, be aware that that could have possible effects on the ability to enforce such claims against infringers. That's a topic perhaps for another discussion. We can't rule out that more detail of the neural network's internal functioning and structure, or more details of the training process could be required, however. And in that respect, there is a recent case. This was issued at the very end of last year. I think it was in November 2020. This was case T161 of 18 that gives some early hints of how the EPA might be approaching neural networks. This claim here is translated informally from German, so any errors are my own. As you can see, this related to a method of determining cardiac output, which, if I can generalize, involved taking a blood pressure measurement measured in one location in the vascular system, and converting that by means of a neural network into a blood pressure at another location within the circulatory system. In this case, the use of the neural network was the only distinguishing feature over the prior art. Other methods for doing this type of conversion manually, so to speak, were known. Now, looking at that feature, the board found that there was a lack of inventive step. They said that the mere indication that weight values are determined by machine learning does not go beyond what the expert would understand by an artificial neural network in the more general sense. The claimed neural network, at least as far as that claim language was concerned, was not specifically adapted for the specific claimed application. The claim features only related to an unspecified adaptation of weight values, which is in the nature of every artificial neural network. So from that point of view, the board didn't take that into consideration when assessing inventive step and found that this method lacked an inventive step over the methods known in the art. But Perhaps more interesting, in that it gives us a hint of the direction of travel, is that the board also found a lack of sufficiency of disclosure based on a lack of detail in the training data. So here are some things that the board said about the deficiencies in that respect. I won't read those out, but it's clear that the board felt here that the level of detail provided in the specification regarding the training of the network and the determination of those weighting values was quite simply inadequate. It was specified that it was important for the data to cover a range of different types of patients, but no examples were given of training sets that covered those types of patients. There was no information about what distribution, for example, of different age groups should be included within the training data set. As such, the board felt it impossible for the skilled person to actually rework the claim method. So not only was there a lack of inventive step, there was also a lack of sufficient disclosure. There are also, very briefly here, a couple of other objections that were raised in a communication ahead of the hearing, but not repeated in the decision itself. So we don't know whether the board found in the end that those were irrelevant, or whether these could still be live issues in future cases. But these included, for example, the structure of the neural network. The application described a particular structure, but did not define, in the board's opinion, exactly how those layers were to be configured, what activation function was to be employed, and so on. They also said, rather cryptically, that there was no information on learned weights. They didn't really explain what they meant by that, but perhaps they are hinting there that there could be an obligation to provide an example of what the weights were in at least one trained network, or perhaps even what those weights related to. We should note this is a very recent decision. It's not yet been cited in any other decisions. It might only be relevant in cases where the neural network itself is the sole distinguishing feature over the prior art, or where the neural net is the subject of the invention rather than its specific application. That remains to be seen. So how much data, if this is really the direction that the board is going in, how much training data do we need to provide? There are obvious questions and issues raised by this, particularly in the field of biotech. For example, your data set could be confidential. It might relate to medical records, or perhaps the training data could be your most valuable business secret. Or it could just be extremely large, as is the case in many genomics applications, for example. It might be impractical to disclose that in the application. If you're relying on a third-party training data set that you cross-reference in the application, how confident are you that that is going to remain unchanged and accessible in the same form that it was at the priority or filing date throughout the entire lifetime of the patent? As in that case we just saw, is the specific composition of the training data important? If so, you might need to provide details as to how that training data is constituted, but this clearly didn't save the case that we just talked about. So it seems that maybe a higher degree of specificity may be needed. Maybe you might need to give more details about the exact balance of different participants, for example, in the clinical trials that provided the training data, demographic data, genotype data, or something of that sort. We don't yet know how this is to be resolved. It is very much a case of watch this space. But one possible consideration is whether you could provide an example of a toy data set, that is a paper example of a data set which, while not being the actual training data that was employed in devising the invention, would nevertheless allow the skilled person to work the invention in some sense. And picking up on that final point that I mentioned on the previous slide, could you provide an example of a trained network, for example, having learned the weights that will allow it to solve the problem? So on that slight cliffhanger, I'm going to hand back to Jeremy to wrap up.
Thank you, Alex. And before concluding, it is probably worth noting that for some AI implemented inventions, there may be greater value in not seeking to patent the AI invention itself, but perhaps seeking to protect by patent or other means the results of that the AI produces. So, for example, if the AI is targeted at drug discovery, it may be better to seek to patent the drugs themselves or newly determined uses for old drugs that the AI helps you to discover rather than the AI itself. Assuming that you are going to protect your AI, then just mentioning that you're using an AI to address a particular problem is not going to be enough. You need to be able to demonstrate that the AI interacts with the other features of the claim in a manner that enhances the technical character of that claim. In essence, we need to get to the bottom of what the AI brings to the party. If it emerges that the AI itself is designed to support some specific technical purpose in a given technical field that the AI has not previously been used for, then it may be possible to achieve relatively broad protection, albeit by reciting a relatively narrow technical purpose. If the use of the AI for a particular technical purpose is already known, then what is it specifically about your AI that makes it better at achieving that technical purpose? Or what additional contribution does your AI provide that previous AIs do not? Does the contribution lie in the inputs, for example, or the outputs of the AI? For example, if you've realized that by inputting both normal images of cells and negatives of those same images into your AI, you achieve superior diagnostic results than based on normal images alone, then that modified input can underpin the technical character of your invention. Similarly, if your AI produces additional or improved outputs representing the technical purpose, then this could underpin sufficient technical character. But as Alex hinted at, ultimately, the success or failure of your patent application may lie not only in what you claim, as in the story that you use your description to tell to the examiner. The devil, as they say, is very much in that detail or technical detail, as the case may be. So thank you all for listening. We'll now move to time of Q&A.
Brilliant. Thank you so much, Jeremy and Alex, for that insightful presentation. It is time for the Q&A. And then, so I'll just maybe easier to hand over to you guys to pick out the questions.
Sure, thank you. There's one question that I've been asked here, which is about the case law examples that we went through there, and indeed the sort of toy examples based on EPA presentations as to what constitutes a technical purpose. And it's been noted that all of those, or the vast majority of them, seem to relate to method claims. And the question is really about to what extent, when we're looking at applications for artificial intelligence inventions in the field of life sciences, chemistry, biotech, and so on, is that indicative of what we see? I think my point of view on this would be that in many cases, if we're looking at inventions in the life sciences space, more often than not, you might be using, for example, a off-the-shelf AI, a standard implementation of some known algorithm or a known means of a convolutional neural network or something like that that's available on GitHub or something of that sort. But where the invention comes in is in the specific application of that to analyze a particular type of data, to look at medical imaging, for example, or to look at genomic data. So in that sense, then a method claim is probably the natural place to end up, at least as your primary claim. It really is that the method of analyzing your data, for instance, using a known AI, might be where the invention resides. But that isn't to say that you can't also have other claim categories. If the invention lies in the AI itself, then maybe you might want to claim more broadly. You'd be looking at what the EPA would term core AI inventions potentially, and that's the sort of thing that Jeremy is better placed than I am to comment on. But there could also be system claims, for example, computer that comprises the relevant software to enable it to perform a computer implemented method. One could conceive, for example, of something like a medical device, an implantable medical device, for instance, that is equipped with hardware that carries out some sort of AI determined analysis of electrical signals or something of that sort in the body, and then communicates those to the outside world for further analysis. So we're not necessarily limited to method claims, but in many cases that will be perhaps the most natural type of claim for something that involves an invention that relates more specifically to the application of the AI than to the AI itself. Jeremy?
Yeah, I think, and I would add to that, you know, very often we as attorneys, we think of the claims as, you know, being directed to protect, you know, the commercial interests of our clients, and that's the most important consideration. But actually, sometimes you can use claims, additional claims, to help demonstrate to an examiner what's clever about your invention. And sometimes, if you craft your claims in the right way, you can use some claims which demonstrate or highlight to the examiner, say, your particular technical contribution. And you might find that even though you're not in the business of selling products and you're more interested in protecting the method, that having an apparatus claim that highlights the hardware nature and the way different features interact to provide a technical contribution, that highlights to the examiner where that technical contribution lies, can actually help to get the examiner on side. Another example actually is system claims. Very often system claims have very little commercial value, especially where the disparate parts of the system might be in different jurisdictions. But if the invention lies at the interface between the different elements of the system, then you might have one element that's providing a very minor piece of information to another element that makes beneficial use of that information. And where you've got that kind of situation, you may actually, by leading with a system claim and highlighting how the whole system as a whole is better, then gain protection for the individual parts of it, and find you have less, the examiner treats the other parts more favourably once he understands the overall contribution made to the wider system.
Brilliant. I think we've come time to end the webinar, and just really to say thank you for everyone that's been able to join us today. You will be redirected to a feedback form, and we'd love to hear your thoughts on how you thought the session went and what you'd like to hear in the future. Also, as you can see, the speakers' email addresses are on the screen, so please feel free to get in touch directly with them if you had any other questions that you wanted to on the topic of AI and life sciences. Lastly, to say thank you, and we hope you enjoyed the session.